This is my monthly webinar series. My name is Brad Micklin. I'm the managing member of the Micklin Law Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law matters, with offices in Nutley, Montclair, New Jersey. The series I'm doing tonight on my webinar is what men need to know about a New Jersey prenuptial agreement. And technically, it's going to apply equally to women also and to same-sex couples, but because my firm is concentrated in men's and fathers' rights, I usually put my information towards men. I want to explain, I'm doing something different that I normally do on my webinars. Normally I do my webinar directly on GoToWebinar and I post it on my website later, which I will be doing. Today I'm streaming to Facebook, YouTube, and Twitter all at the same time, so bear with me if I have any kind of technical difficulties as I'm approaching the information that I'm going to. All right, so let's move right along into the information. All right, so give a little information about myself to those that haven't worked with me before. This is me. And people on Facebook know it's me, but on social media, this is me. I've been a practicing attorney since 1996. I left law school and I took a judicial clerkship in Bergen County. I then went to do complex commercial litigation for a number of years, and then I went into private practice with Kessler & Associates in about 2000. That's probably about 98, actually. I did that for a few years. Then I opened my private practice in 2001. At the time I opened my practice, I was a general practice attorney, which means I did a little bit of everything, but I quickly realized you can't really do everything well. So I decided to concentrate my practice as it is today. Give you some background for those that haven't worked with me, just so that you have an idea of my experience. Here is some slides. I've been fortunate enough to do some media appearances recently. You'll see some of them on my website. I've appeared on Fox News, Law and Crime, I-24 International, and a few other sites. And then next also is just some awards I've been fortunate to receive in the past. They're a little outdated, but I had to update them. And I show the last two slides not to impress you, but to impress upon you that I do have a good deal of experience. I care a great deal about what I do, and I like to believe that I have a good sense of what I'm talking about. So hopefully that shows, at least to some extent, the background and experience that I have. But enough about me. Let's move on into, oh no, actually, I'm sorry. One more thing to talk about before we move into the information. All right, so part of my practice, I offer a support group for men going through divorce and custody matters. It meets at my office in Nutley on Washington Avenue the last Wednesday of every month at 6 o'clock. I may be moving it to 6:30 because I think 6 o'clock is difficult for people to make, but at least here's some of the information. If you're interested, you can also email me anytime asking any questions about it. Okay, so with that, now let's move into a little bit about what we're going to cover. And let me give you a little background just simply on the format too, especially if you're watching this through the GoToWebinar so you don't actually see any person. The webinar is intended to be about 60 minutes long. I try my best to time it, but I never really know how long something's going to be. Sometimes it's longer, sometimes it's shorter. I do take questions at the end. Normally it would be posted through the GoToWebinar, but you can also, if you're watching on Facebook, you can send me a message or you can post it on the screen. My YouTube page, you probably have to comment, but I don't know if I would see it. So the best is probably to email me a question. There is, on the GoToWebinar, there's a chat panel on the right side, a control panel, where if you wanted to send a message, if you're watching it through that form, you can also send it that way. And on this GoToWebinar also is the handout in case you wanted to download it. There's not a great deal on this PowerPoint that I think is worth downloading. It doesn't have a lot of statutes or cases cited to it, but if you're interested in having it, you can have it, or you can email me for a copy of it. Lastly, this will be posted most likely on my website in a couple weeks, so if you don't get to watch it all, or if you can't finish and you have questions, you can always go back and watch it there also. So with that, let's talk about what we're going to be covering tonight real quickly. First, I'm going to tell you a little bit about what a prenuptial agreement is and just explain sort of the basic components. I'll give you the reasons why you want to have a prenuptial agreement, what is necessary to make it enforceable, the paperwork that you need to attach to it, the different pieces or components, how it can affect child support and other custody-related matters, what you need to do if you want to change it after you've signed it but before you get married, some changes in the New Jersey law regarding the enforceability, as well as some tax code issues that have come up in the last year or two. And lastly, just some other things that you need to know, and again, just going about new changes and updates in the law. All right, so let's move on to first. So we're going to talk a little bit about what is a prenuptial agreement. So, and a lot of people think they understand what it is, and there's a common sense understanding to it, but it is really important. There's some specific nuances that I think are important. So first of all, it's a contract that's made in contemplation of marriage. There is something that can be done after you're married called a postnuptial, which is similar in its form, but very different in its legality and its requirements. It is binding and enforceable only when you get married, which is important, a distinction, because it's meaningless up until that point. And a lot of people don't realize that, because a lot of people sign a prenuptial and then continue to live as an engaged couple for a period of time thinking that they're bound by it, and it's not actually the case. It sets the rights and obligations of each spouse in the event of a divorce, and that's really ultimately the purpose of it, which may sound basic, but for those that aren't familiar with it, it's going to be it's meaningless before you get married. It's also meaningless while you're married to a great extent. It only becomes enforceable and relevant if you're going to get divorced. The mid-marriage is just another term for a postnuptial, like I mentioned earlier. It resolves the issues of division of property and spousal support and estate planning. I'll mention estate planning separately because I have a little bit of an issue with that, but it often is included into that. I'll just take a quick hello to see some new people signed on. Appreciate the support. Hope the information is helpful. To those that are on my Facebook, you can always message me if you have a question during this, although I might not see it because my phone's kind of tapped into the media, but you can try it or message me on the screen. Anyway, good to see you guys. All right, so I'm back to social media. Resolves the issue of your property, and it also can resolve any other issue as long as it doesn't, quote, violate public policy. And the most common example of that would be child-related issues. They can often be problematic in a prenuptial agreement, so it's not very common to include those provisions, and I would recommend that you stay away from them, generally speaking. All right, so let's talk about what is a prenuptial agreement. All right, so the first thing about a prenuptial agreement is it's about the rights and obligations you have to any of your property. Now, and it's not just the property that you had before you got married, but it's also post-marital property. It will usually speak of how property that's acquired after you're married will also be treated in the event of a divorce. And that's important because a lot of the property that you have before you're married, in many ways, has different characteristics and components after you're married. So a premarital asset, for instance, can also have a postmarital component, like a house that goes up in value or a business that starts producing more income. So you may need to define, and you should be defining inside the prenup, those issues. Next, it gives you the right to manage and control property. And this is meaning during the marriage. You want to have definitions because not only your ability to protect the value of the asset, but you may need to be managing it. You may even need your spouse to be managing and handling it, but you want to ensure that the classification of it still remains as premarital, so you can define the rights inside of your prenuptial agreement to how it's going to be managed. Also can define how it's going to be disposed of, both before and during your marriage. It will often speak about modifications or elimination of spousal support, a very significant issue. There's a lot of options when it comes to spousal support. I often recommend, and not often, I always recommend, that you put serious consideration into those provisions, because prenups don't have to be you get no alimony, and that's one of the greatest challenges to prenups, specifically in the past when I talk about what the law was back then and how it's different today. But I still think it's going to be a significant one going forward. And as the economies change, that's going to be significant. So consider alimony and really put some thought into the provision. It doesn't have to be either you get a lot or you get none. There's a lot of different ways to handle that. Okay, so not really sure what that was. All right, making a will, trust, or other arrangements. You can do this in a prenuptial agreement. I don't necessarily recommend it. Many prenups that I've seen, even some of the ones I've drafted, have had provisions that say that the other spouse will not inherit premarital assets through a will or intestate, which means if you don't have a will, unless that person chooses to make a will, him or herself. I don't agree with that because, and I say it only because it's commonly put into prenuptial agreements. The prenup is only supposed to manage the property and division of assets in the event of a divorce. So if you happen to be married and you pass, then I don't think it should apply, and I don't think that's the intention of it, unless it's specifically added. So it's something to watch for, because it's a common provision in it that I think really is contrary to the purpose of and the intention of your prenuptial agreement. We talk about ownership rights and death benefits from a life insurance policy. Now, you have to be careful with life insurance in all kind of aspects of a divorce and estate planning, because the insurance policies will often have a named beneficiary. So you want to make sure that that matches whatever you're doing with regard to it in your prenuptial agreement, because if there's a conflict between what the policy says and what the prenuptial says, it's going to be serious issues for your heirs, not for you because you will have passed, but you're leaving a significant problem for those that remain. They will always have a choice of law provision, which basically says whose state law will apply when it's questioned or challenged or even just introduced into a court. This should be where it's being signed. A lot of people think it has to be where you're getting married or where you're going to live. I don't necessarily agree with that. It should be where you're getting signed. It also should be defined in the agreement where it is and why it's there. Some states will allow you to do a prenuptial agreement in a different state and still have it bound by that state. Like, for instance, New York does that with wills, for instance. If the will is valid, wherever you execute it, it'll be valid there. I don't recommend doing that for anything, even when the state says that it can be done, because it just leaves an ambiguity and also possible problems if the laws change in your future. And lastly, any other matter not in violation of public policy, which is a provision you're always going to see with most family law divorce issues. They always leave a general catch-all. Now, there aren't many reasons that I've ever seen into a prenuptial agreement other than the financial issues that we just mentioned. So when it speaks of any other matter, it could be truly any other matter other than like custody matters. And I guess technically it could be a custody issue too, so long as it doesn't violate the state laws and rules about child custody issues. It has to be consistent with public policy. Doesn't mean you can't have custody arrangements in there or child support. But also you can have what you're going to be your living arrangements defined there. You can put household responsibilities, how finances are going to be handled, who's going to manage them. I've never seen it in a prenuptial agreement because I don't know how significant or relevant it would be, but you certainly can have it in there, and if it's germane to your relationship, you should consider doing it. All right, so why have one? And this is a big question because I'm asked this all the time. And I personally think, my opinion is all people can benefit from having a prenuptial agreement, not because, and before I go into the specifics of my slide, not because you want to eliminate your financial obligations in the future, but it helps you define how you're going to conduct yourselves and make decisions while you're married. It also discloses to the other side, and we'll get into this later too, how you use credit cards, what kind of income you make, what savings you have, what kind of debt you have. I still see in 2018 dozens and dozens of couples every year coming to me saying, I don't know what my husband makes. I don't know how much credit card debt we have. I don't know where my wife has her banking account. And that's very problematic because I think one of the greatest strains on a marriage is finances. And having a prenup in advance puts that out on the table. Not only what you have, how you use it, how you're going to handle it in the future, and how you handle it when you get divorced. I personally think it makes sense for all relationships. But let's go into the semantics of why most people would benefit. First of all, it makes your divorce process easy, simpler, and significantly less costly, because most of the issues should be resolved inside of the prenuptial agreement. Gives you emotional peace and financial. To those who have been through a divorce or know people have been through a divorce, it can be one of the most taxing experiences a person's ever gone through. And anything that will eliminate any part of that is tremendously valuable. And a prenuptial agreement will generally most often eliminate most of it, almost probably 90% of the difficulties that come along with a divorce. Also gives you extra protection. And this is important too. So first of all, the laws define what is marital property and what is not marital property. Like on the slide, you're seeing gifts, premarital assets, inheritances are already defined in ways that protect them. But they often will change, as I was mentioning before, their classifications, even though they don't change what they are. And it gets convoluted, like the example I gave before, house that goes up in value or the business that starts producing more. So having a premarital agreement eliminates that. It will often also generally eliminate your alimony exposure or limit it significantly, if not completely eliminate it. It will address how to determine support obligations if you haven't set a specific like alimony. Now, it will generally won't include child support, but you can define a mechanism or formula by which alimony will be determined, or even how your assets will be valued in case you're not choosing to have the agreement separate everything. Meaning the normal prenuptial or the standard prenuptial agreement will generally say whatever is premarital stays premarital, whatever is acquired during the marriage may be a marital. But that may be convoluted, as I've referenced a couple times. So you might want to instead develop a formula by which you'll define it. Like for instance, I did a prenuptial agreement for a client whose wife that he was going to marry, or his fiance he was going to marry, had a home, and they were going to live in it and contribute to it. So like the example I keep mentioning, it would be more valuable through their marriage. We defined a mechanism to actually to calculate the value that he will have contributed to it, and financially and physically and emotionally through family support. And now there's a way to define how much he should receive, so it's not he gets all or nothing. It also defines how you handle divorce or property during marriage, which I mentioned a moment ago, why I think prenuptial agreements are so important to people. Because a lot of times you don't know what you're going to do until you actually get married and you're living together and you figure out who's paying the bills, how are we going to bank. And it's an immediate strain on a relationship if you haven't covered it beforehand. This one is actually kind of just a rephrase and expedites the divorce process. I'm sorry to put that in, should put there. And lastly, most importantly, it limits your court and attorney's time, which means your legal fees and costs. Not only in legal fees, but time off of work, time away from your family. It's a lot. The one thing I want to add here also, along the lines of how it reduces and eliminates your litigation, there are still people who will contest it. So when you're going into a divorce, if you have a prenuptial agreement, there's three things you need to do in your beginning of the process. The first is that when you file your divorce complaint, you must mention in what's called the wherefore clause that you're seeking to enforce the prenuptial agreement. You may even want to attach it. Make sure you have the full copy and signed. That's important because if it's not in your divorce complaint, you may not be able to seek it in your divorce. Second is you want to see if the other party is going to be contesting it, because if not, you should enter what's called a consent order indicating that you both agree that it's enforceable, and send that to the court so that the process is streamlined and eliminated. And lastly, if there is going to be a contest to it, because there often is, then you want to file a motion early in the divorce process to enforce the agreement. You don't want to go through the whole process expecting it to become the intended outcome and it not be, and then you have to start all over again about the prenuptial agreement, because the court may have to have what's called a plenary trial to determine whether or not the prenuptial agreement will be upheld. So you want to do all these steps in the very beginning to ensure the quickest route to enforceability. All right, so when does it become enforceable? And I talked a little bit about this when I first signed on. because it's, I think some people make a generalization about the agreements, but it's only effective upon marriage. So again, if you're going to be living together for a long period of time before getting married, don't be confused and think that you're bound by this or that there's any restrictions. So for instance, there might be marital assets that you're sharing, agreements that you made that you think the other person is abiding by, and it's actually not going to be the case, or it may not be the case. They're not at least required to. Second is make sure it complies with, I'm going to underline it for the people watching the webinar, make sure it complies with the current statute. And that's important because New Jersey's laws changed. I'll probably mention this a couple of times throughout the presentation. There's been a significant change in how New Jersey handles prenuptial agreements, especially for enforceability. And if you have an agreement that doesn't mirror that, it's going to be a problem. And I said that because a lot of people will go to the websites and do the how-to forms themselves and download it, and it's not going to be in compliance, and that's going to be a serious issue. So you have to at least make sure that you're familiar with the law. You could try to read it on the internet. I'm not a big fan of people who do that. You could and should at least consult with an attorney, get some idea about it, and then decide whether or not you're going to use the how-to forms and the internet things. Has to be knowing and voluntary, which means there can't be any coercion, which is the next one. And coercion comes in a lot of different modes. It doesn't have to be a physical force. Coercion could just be sign this or we're not getting married, or the wedding's tomorrow and I'm calling it off, or I'm going to disclose certain information to somebody else. Any kind of, I guess for lack of better words, harassment or threats or pressure could be, and even subtle pressure. When you're planning a marriage or you're planning to get married, there's always a lot of pressure. So it's easy to sort of kind of put the screw in on a certain issue because you're trying to get this done quickly, and it may turn around and be problematic in the future. So don't do it, and make sure that the person doesn't feel that you were doing that in any way, because different people have different levels of sensibility. There should be an opportunity to consult with an attorney. You don't have to. I think you should. It'd be a mistake if you don't, in my opinion, not because I am an attorney, but because I just understand the significance of these agreements. But it has to you have to have at least had the opportunity, and it should say that inside of the agreement that you've had it, and if you don't have an attorney, that you waived it, again, knowing and voluntarily. The next one's probably one of the most significant. Must be full financial disclosure inside the document or attached to the document, meaning you can't just say we had full disclosure. The numbers of assets and debts and income and all the other issues need to be either included in the body of the document or attached to it with statements. Next, it has to be fair at the time of execution, which is one of the biggest changes we've had in our law. It used to be, it has to be fair at the time it's being enforced, which means at the divorce. Now it has to be fair at the time of execution. So all of these factors are going to be important to that kind of analysis, as well as many others that may not be here. So you just want to make sure, and that's why I always say speak with a lawyer so that you have an idea of what issues are significant. All right, so let's talk about a little bit about what needs to be attached to your prenuptial agreement. And it's going to be similar to a divorce, but what I mean by that is not that the paperwork to like a divorce complaint, for instance, is similar to a prenuptial agreement, but the financial disclosure would be what you would have to do in a divorce anyway. Even though you have a prenuptial agreement, the prenuptial agreement needs to have it. Now, to go a little more into detail from what I was talking about a moment ago when I said it has to have full financial disclosure. Has to have information on all of your assets and debts. It can't be generic, like, all of our credit cards are premarital. It needs to specify what credit cards you have, what credit card debts you have. It should list, I'm actually going to put these all up first. So it's real property, personal property, jewelry, vehicles, furniture, credit cards, and other debts. Now, I put that up just as one so you don't have to sit and watch it go through all of them, because all of my things should have, at a minimal, appraisals of the current value, specifically very valuable property like real estate, jewelry, cars. Your credit cards should have, the most recent statements. Assets like retirement accounts, bank accounts, investment accounts, anything that's sort of liquid should have a current account statement attached. You should have a current tax returns attached so that your income information is updated. The more information you have, the better. Let me just move to the next slide because that's what I was just talking about. Tax returns, W-2, pay stubs, bonus information, stock holding with information. Anything that you have or owe should be documented as well as you can. You may even want to put the purchase statements. While appraisals are very helpful, but appraisals will vary and fluctuate, you can also consider putting like your HUD statement for the closing, the title or the loan information for the mortgage or your car loan. Kelly Blue Book, I don't know if that's even still around actually. And anything else you have, anything that you can put, the better it'll be. All right, so a little more about the paperwork. I usually recommend, and this isn't necessarily a requirement, well, it's not really much that's technically a requirement, but I always like to put in what you're anticipating to happen. And that's mostly based on the way the law used to be. So the law is very different in certain aspects, but I still think that this applies. I put in what you're anticipating to happen or what the basis of this agreement was. Like, for instance, if you're going to have an alimony component, why you think alimony should or should not exist. What were the considerations? Where were you at this place? Where were you going to be? So like, for instance, potential inheritances, gift from relatives. There may be substantial monies coming in the future. You may want to include that so that it's disclosed as a potential and it's considered. It makes it, it adds to the basis of how strong and fair the agreement was when you first entered it, because you're disclosing even potential issues like large inheritances. Having children and the intention of staying home. If one party is going to be the caregiver and one's going to be working, that would be important to indicate that so that it's understood that one person, for instance, was possibly surrendering a career for a long period of time, especially if they were not going to be getting alimony under the agreement. It would explain, again, at that time, why it was a fair agreement. Very important to put these provisions in. Increases and decreases in income, changes in employment. Again, if the more that you can show that these issues were contemplated, the better and stronger the agreement will be. Going back to school, along the same lines as changes in employment. If you're going to be taking off time at work, when you're going to school, you're acquiring an asset, hopefully at least. Somebody just called me. I don't know if it messed up my recording. All right, so sorry about that. There's a technical difficulties I said I might be having because I'm doing a lot of new posting. So going back to school, like I said, you're acquiring an asset usually. You're often also acquiring a debt by school loans, and employment's going to change. You're also going to be out of employment. So it would be important to list that there. And then how and whether or not you're going to be acquiring property separately or jointly while you're married. Very important, because aside from the issues I mentioned before, how properties can change during and after your marriage, you want to also define when you do acquire property, how you're going to characterize that, because you might be using the premarital assets to purchase a marital asset, like taking money from your premarital retirement account and buying a home together. Well, you want to know beforehand whether or not the money that's going into the home is protected or not, and issues like that. All right, so just checking in real quick on Facebook, saying hello to people just signed on. Good to see you again. Hope you like the information. And also, if you would rather be watching it through the social media and seeing the PowerPoint, you can always jump onto my YouTube page. It will also be on my website probably in a week or so. All right, so the components. The agreement itself, first of all, it has to be signed by both parties. And that would seem almost like axiomatic, but I'm saying it not just to make sure you know you have to sign it, but you have to make sure to keep a copy of it. More often than not, because I see a prenuptial agreement may come 20 years later, and people don't have the signed copy of it, and it's problematic. So you need to keep and maintain a copy of it. It's easier now than it used to be because there's a lot of electronic storages, and you could probably introduce a photocopy or electronic copy where you might have originally had the original, but it's disappeared. The schedule is outlined in a financial picture and supporting documentation. I can't say that enough. Put it in the agreement, also attach it to the agreement so that it's clear that everybody knew it. Now, when you go to get divorced, there are still going to be, and I want to quickly say to the people watching on social media, I can't see how the screenshot looks for the PowerPoint, so I apologize if it's not clear, and if it's not in the future, I'll try to fix it. But so moving back to this, your divorce complaint, your answer and counterclaim, and incorporate into the final judgment. It's not going to change your initial paperwork. As I mentioned earlier, in your divorce complaint, you want to mention that you want to enforce the property settlement agreement. If you're answering a divorce complaint with the answer and counterclaim that I mentioned here, then you want to include in that wherefore clause, which is the ending part of it, that you want to enforce your counter or your prenuptial agreement. And in a divorce paper, which is usually the final judgment at the end of your divorce, would also state that it's going to be enforcing the prenuptial agreement. It's also even helpful if you attached it to all of these papers. Okay, so how a prenuptial affects child support during divorce, and kind of custody issues too. They will generally, they're generally not enforceable if they're against public policy, and that's hard to define. The standard in New Jersey for any issue regarding a child is what's in the children's best interest. And the courts do and should defer to the parents' judgment when deciding that. So putting a provision in a prenuptial agreement about your children or your future potential children, or actually it could be even the children you have at the time that you're doing this, doesn't necessarily mean that it's not going to be enforceable, but you have to be very careful at how you word it and what issues you address for it. And here's an example. A premarital cannot eliminate or significantly reduce the right to child support, to receive child support. That would be clearly against public policy. So those are one of the issues you want to stay away from. I've never seen a person try to put that into a prenup, but it's just good to know that you can't. And you should be careful addressing any kind of child-related issues. All right, so now what happens if you have an agreement, but you want to amend it? And you can, but under only certain circumstances. You can make changes. First, the agreement has to say inside the agreement what is required to make an amendment. Usually the standard language is going to be that anything that is changing the terms must be signed by both parties. Probably signed and notarized is usually best. But that should be in there. If it's not in there, you might not be able to amend it at all, even if you did do it in the writing. It becomes very, very convoluted, so I wouldn't change it absent that. It also technically can't be changed. Well, I guess it could be changed after marriage, but I was going to say that, in my opinion, if you change it after marriage, you might be making it a different agreement. You might be making it a mid-marriage or post-nuptial agreement. And the enforceability laws and the interpretation of coercion is significantly different in a post-nuptial. And I'm not really going to cover that in here, so it's not something I recommend doing. I would do a specific post-nuptial agreement, a whole new agreement, so there's no questions. All right, so let's talk a little bit about the old laws and the new ones, because first of all, a significant change in the new law, and your agreement may be bound by one or the other depending on what terms you have in there. If you don't have terms in there, then it's going to be bound by the current law. So, but let's look at the old law first. In 1988, the Uniform Premarital Act. The main part that made prenuptial agreements so problematic up through 2013 was the change, is the enforceability and the fairness of it was viewed at the time of the divorce, which made many prenuptial agreements subject to attack because circumstances had changed so significantly from between the marriage and the divorce that almost all not almost all, but a lot of prenuptial agreements became unfair because things have changed so significantly. You could have 20, 30 years of marriage where a spouse, left work and raised children and or became disabled, and now you had, even if all that had been contemplated, well, the disability won't be contemplated, but even if you had contemplated increases in salary, absence from the workforce, and put all that into the agreement under the 88 law, if the courts felt it was unfair 20, 30 years later, they just did away with it. And knowing that caused a lot of people to challenge prenuptial agreements just because it was easy to do so, even if they were completely fair at the time, even if they disclosed everything and everybody knew what was going to happen in the future, to the extent that you can. So come 2013, the Uniform Premarital and Pre-Civil Union Act changed. The new law, I think, is a lot better. First of all, it now obviously addresses same-sex couples, which wouldn't have technically been bound by the old laws. It made them easier to enforce and less subject to challenge. It basically says now it has to be fair, like I said earlier, it has to be fair at the time that it's executed, the time that you sign and enter into it. And that's the way it should be, because you're making the agreement at the time. If change of circumstances could be a reason to destroy a prenuptial agreement, there would be no reason to enter them. And that's why you'd see a lot of people that were challenging them up until that 2013. So additional changes. They defined unconscionability so that if there's if you're opposing it, the other spouse is opposing, it's not like in the past where you could just say it wasn't fair. You actually have to meet one of their criteria, like you didn't get full disclosure of the finances or the earnings. You didn't voluntarily waive the right to get the information if it's not in there. Some people do say we're waiving the information, which is a horrible mistake in my opinion, but some people do it. So if you did it and it doesn't say that it was voluntary knowing and you had a choice to get an attorney, that still will subject it to challenge. You didn't know or have the opportunity to get the financial obligations of the other person, and you didn't have time to consult with an attorney. All very important issues, all of them still relevant even with the 2013 changes. Probably the most important, going back to the last slide, because whether you have an attorney or whether you waive an attorney, it's more important actually whether you had one, but even if you waive it, to know that you knew you had the choice, you had the time to do so, and then you waived it is very important. All right, so what do you need to know, lastly, about a prenup if you have one? And the most important thing to know now is the tax law concerning alimony is changing come 2019, and that's greatly going to impact people that have prenuptial agreements now, or even those that are entering into them in 2018 if they don't know. Because as I mentioned before, a lot of people are using these online forms, and they may have generic language that's inconsistent with the current tax laws. And this is federal, so it's not just limited to whether or not you live in New Jersey, but I'm only talking about Jersey. The most important thing to know is the prenuptial agreements in the past were all premised on the tax code at the time where alimony was tax deductible. So the person agreeing to pay alimony, or even the person receiving, more important, the person paying it, was relying upon a significant tax break or deduction for the payment. And the number that he or she agreed to pay would have been based on that assumption. Well, if you sign the agreement, it could be yesterday or 10 years ago, and you get divorced in 2019, the agreement is binding, but the law about your tax deduction has changed. You won't get it, so you're paying significantly more in alimony than you contemplated. And the current law about prenuptial agreements says if it was fair at the time it was signed, it's enforceable. So now there's going to be a huge conflict, because the old law said if it was unfair, if it's unfair when it's being enforced, it's subject to challenge. And now it's saying if it's fair now. But the question becomes, is it fair now if you relied on such a significant tax break that you're not getting? So there's going to be a huge issue for people with prenuptial agreements if and when they do get divorced in the future. And it's anybody that has a prenuptial agreement, even if you're going to enter into one in the near future, in the next month or so, I definitely urge you talk to a divorce attorney so that you can learn the impact of the change of laws and how that's going to affect the agreements, both in your alimony payments, but also as well as your distribution of assets and debts and all the agreements that you're going to be entering into. All right, so that is the end. I'm going to wait here to see if anybody on my GoToWebinar has posted any questions. And I'll also check back on my friends at Facebook. those that are hanging on, still watching with me, appreciate the support. Real quick, because there's a bunch of new people I see here, you can only see people on this screen that are friends of both of us. So not that that may give you any more comfort in posting information or questions here, but at least, you know, if you post something on the screen as a question to me, the only people who will see it are the people that you know that I know. Now, if you don't want them to see that, which I would completely understand, you can send me a messenger or an email. Same to the people on YouTube and Twitter watching right now. If you don't get a chance to post any questions, you can also email me at brad@micklinlawgroup.com. So I'm going to wait. I don't see any questions here. All right, so I'm just going to go to those on my social media. Hopefully you can read these slides. I'm really sorry if there's like a light on them or not. I can't see. So I'm doing my best to keep the camera focused on them. And I'm going to be signing off and wish everybody good night. I will be on tomorrow for my daily tip. Let me tell you why you're here. That's assuming that you're not watching this any other day but the 29th of November. So I'm going to be on Friday tomorrow doing my tip at about 4 o'clock. I don't know what it's going to be on yet. If anybody watching on any of these forums wants to send me an idea or a question that you might have, I can make a tip out of it. With that, I'm going to say wish everybody good night. Thanks for the support. Hope the information helped you, and I'll talk to you guys soon.